All right, the pandemic has put a wrench in plans for so many, but it also looks like there'll have to be a new normal moving forward for couples looking to separate or co-parent. And today we're answering your most pressing questions. Tanya Davies from Davies Law Firm joining us. Good morning, Tanya. Thank you for your time.
Good morning, Leslie.
I probably know the answer to this, but you're probably seeing an increase in requests for separation agreements and divorces right now.
Absolutely. Unfortunately, yes.
Yeah, unfortunately. All right, let's get to some of the questions here. Number one from our viewers. My ex has a job that requires a lot of travel, only in Canada, however. He's scheduled to take our kids for the summer months. Am I allowed to ask him to self-isolate for 14 days before he takes them?
Well, the answer to this question, Leslie, is the following. You can certainly ask, but it doesn't mean that her ex-husband is going to comply. Possibly he would not be in a position to do so because of his job requirements. He cannot take so much time off work and then spend the whole summer, 2 weeks in the summer with the children. So if he's not capable of doing so, and if it's not on consent, you can ask him, how often do you travel? When was your last travel? And do you comply with all the safety requirements that Health Canada imposes on us? And if the answer to these questions is yes, unless you have concrete evidence that he's not complying with these requirements, the courts are telling us that there is no reason to say that you should withhold access.
So the onus is on her to prove that it's a risk to the children's health, not the other way around.
Correct.
Okay. Number two, my ex and I have joint custody for our daughter. She won't let me see her because she's afraid of COVID-19 transmission during housing transfers. Her daughter, or their daughter, is asthmatic. Is there anything I can do?
He can certainly bring an emergency motion in court. Again, the same rules apply. The ex-spouse needs to have concrete evidence that the person who is exercising access, even for an asthmatic child, that he's not complying with safety protocols for COVID-19. And if he is, and if the child is being transported in a private car, she doesn't come in contact with any people around, it's not public transport, then there should be no issues. COVID-19 in and of itself is not a good legal reason to withhold access.
Let's talk about other emergency motions you're hearing about right now. What are some of the most common ones?
Mostly they would be related to access, whenever access is being denied, or whenever the primary residence parent is being proactive and they're saying that the access parent cannot comply with the safety protocols. And if they have concrete evidence, instead of resorting to self-help and unilaterally withholding access, they ask the court to make a proper decision that access should be denied, but for a legitimate reason.
So again, if the ex is acting smartly, the onus is on the person who's worried to prove that they're not acting smartly.
That is correct.
All right, let's move on to the next question. I want to go on holiday with my kids within Canada. Do I need to have the other parent's permission if I have sole physical custody?
The word custody, Leslie, refers to decision making. So if there is no court order or separation agreement in place that actually states that the primary residence parent has sole custody, and if it's only an agreement, and if they're making that conclusion based on physical primary residence of the child, that does not grant them sole custody. And even if they did, for as long as the access parent is entitled to exercise access, you cannot just unilaterally take the child away, even if it's within Canada, to a different province, for example, for an extended period of time. It would interfere with the access parent access, and they would be entitled to make up time in the summer. And the second reason and an important factor is that the primary residence parent taking the child away would have to provide an itinerary to the access parent. How are you getting to the province where you're traveling? Are you flying? Are you traveling by car? When are you leaving? When are you coming back? And when will you stay there? And what is your contact number so the access parent can contact the child?
Does it have to be in reasonable driving distance? For example, if somebody from Ontario has a cottage in Quebec, can they take their kids and the person who's objecting can't because literally it's an hour and a half away?
It really depends on the length of time that the child is being taken away. If it's for 1 day, maybe the requirement is not as stringent to inform the other parent. But if it's for a week, for example, for summer access, that's important to inform the access parent.
All right, next question for you, Tanya. My wife and I agreed to get a divorce at the start of the pandemic. We're both isolating in our home, but am I considered separated even though my spouse and I still live together in our home?
If both of you actually consent that you're no longer a couple, that there is no prospect of reconciliation, and that you're set and you have serious intentions of getting a divorce as soon as this pandemic is over. Legally, you could be residing under the same roof, but be considered living separate and apart for the date of separation purposes.
And what does that change? Like expenses? Give me a list of how that will be. If you're still living in the same house, you're now separated, you've agreed to it, what's going to change?
What's going to change in terms of an important factor where it matters that you need to declare that you're living separate and apart is the date of separation. In order to get your divorce, you have to be residing separate and apart for at least a year. So if you agree that this year starts running from the time when you said to each other, we're legally separated, we have the intention of getting a divorce, then you could be residing at the same home, and the time starts running from the time when you actually declare to each other that you have your intentions to separate.
Perfect. Tanya Davies, lots of information to digest there. Thank you. Tanya, of course, is from Davies Law Firm. Appreciate it.
Thank you, Leslie.